Okay, we are now live. What's going on, everybody? Welcome back to the channel. My name is Nate, lawyer slash YouTuber, and today we are going to talk about some crazy stuff that's been happening in the past couple of weeks. We're going to talk about two lawyers who, for some reason, chose to throw Molotov cocktails at a protest in New York. That's a crazy story. We're going to get into that. We're also going to get into the Insurrection Act, having military forces in the United States for law enforcement purposes, and the interesting pieces of that little legislation. And then we're going to talk about religious freedom and a very interesting case. And it's fascinating to see how some of the top legal minds in our country describe and interpret the law in one way and another group the other way. So we're going to get into all of it. It's going to be a fascinating day. So let me introduce you to my two friends, people who are you don't believe, great guys. First, you guys know them. This is Uncivil Law
with camera issues. Hello, everyone. How are you doing?
I'm doing fine. We just talked for like 20 minutes before this, but I am doing fine. How are you doing?
I'm doing fine. I am alive and well and intact, which is good news.
Oh, I got people to ask me for the lamp. So
the lamp.
Sorry,
yes, the lamp is the administrator of justice. We need the lamp.
Yeah, the lamp is back. I'm sorry. Now I got to bring you up to my other boy, Viva from Canada, the Canadian lawyer here. What's going on?
Nothing much. I saw a skunk in the wild today in Montreal, in Mount Royal. Beautiful.
A skunk? Oh my God!
5 feet from us.
One thing, I'm always afraid. That's one of those animals I'm afraid. Whenever I see one, I'm like, oh my God, because I don't want to hit you with that spray. What is that spray? It's
you've got a good 3 seconds when you see its tail go up to run. But no, this one was very docile and used to people. It was up in the park, so I think it's between kids.
I don't want to. I want to call you the, what is it? The Tiger King, the Skunk King. Right? Well, first, everybody in the chat, thanks for stopping by. Again, if you want to throw us any questions, super chats are more than likely. Also, hit the join button if you want to join the channel and join the crew. I want to thank everybody for being here and watching. So we're going to get into the content today. Today, I'm going to start with these two attorneys. Now, I'm assuming you guys have heard this story, right? About the two attorneys who were in New York and with the Molotov cocktails. Have you guys heard about this story?
I missed that one.
Oh, so we got to give you the, what do they call it? What do the kids say? The TLDR now, right? The TLDR. Yes. All right, so here we go. Let me make sure we can all see this. This is some crazy crap. All right, so this is Fox 5 New York. Two lawyers accused of firebombing an NYPD vehicle during the protest. Now, as you can see what this woman is holding, she has a Bud Light can stuffed with some liquid and toilet tissue, and right at the top is toilet tissue so she can film it. Now, right beside her is the other lawyer. So these are two lawyers. Now, these lawyers are from some serious schools. The guy is from NYU. This is like the number 4 law school in the country, a graduate of NYU law. And this woman, she's a graduate of Fordham Law. So this is crazy. These are not like just some two nobodies. These are two lawyers who've come from very, very good schools. I got a super chat real quick. This is from Grammy Pace. Did you see the videos of the reporter shot with pepper spray pellets, and the CNN reporter who was arrested? Yes. I definitely saw that. Thanks for the super chat, Grammy Pace. Yeah, we definitely saw that, which was crazy, which was insane too. But now, back to the story. So this is the picture of her, handing out, because they were being charged at handing out these Molotov cocktails. So here are their names. They're two licensed attorneys in New York, and it says here that they were attended 2 prestigious schools. So this is what happened. The judge now has been a little lenient on them because the prosecutors were saying you should keep these people in prison. They're throwing Molotov cocktails at police. Keep them in prison. But the judge says this, and this is a quote: "One night of behavior is not a basis on which to reject somebody's ability to make rational decisions." So first, let's stop here. What do you guys think about that? The judge is saying they had one bad night. It's okay.
You may not be able to reject their ability to make rational decisions, but you can certainly accept their ability to make irrational decisions. or even a bigger problem, maybe it was a totally rational decision what they decided to do, which makes it even worse. From what I saw, I don't know if it's in the story, but the guy was working at a big law firm, and over the weekend they took his name off the site.
Yeah.
And I don't know if it's the same thing in the States. I suspect it is. Lawyers have to have a clean criminal record. And so these lawyers are probably going to have problems sooner than later with their disciplinary committees or whatever.
The disciplinary are going to have lots of fun with these people. Yeah, these people are getting at least suspended for some period of time. But here's what I think about the one night of bad behavior thing. It's not that they were in a place and got swept up in a period of emotion and did things they would not otherwise do, right? It isn't that they succumb to a mob mentality in that way. What is it? Well, apparently they had enough forethought and planning to obtain the Bud Light bottles, fill them with some kind of fluid, stuff toilet paper into them, and drive to the scene of where they were handing them out. So that's what we show as preparation and planning and intent.
Premeditation,
huh? There's premeditation. So it's not, I just got swept up in the moment. It is, I deliberately planned to do these things. So would I give them a break based on their generally good behavior? Yes, but not that big a break.
Well, the other thing is just apply that statement mutatis mutandis to any other violent crime. One night of bad behavior is not a basis.
That's right.
You know what? Right. It might actually be a basis to lock somebody up for a long period of time. I'm not suggesting that should be done here. This is beyond bad decisions or rational decisions. The problem is this was a rational, calculated decision, seizing on an opportunity, and it's not like throwing a rock on site, which I'm not sure is much better, or it's not worse, but I'm not sure how much better it is. This is potentially deadly, and it's the amazing thing. So I told Nate I'm reading this book or listening to it on Audible now. John Posner. It's the So You've Been Publicly Shamed.
Or is it Posner?
I forgot. I'm an idiot. I'll check on Twitter. But the one line from the book, I don't know if it's his or someone else's, is that the snowflake is never responsible for the avalanche. But this is like, at some point, people think they're snowflakes in an avalanche until they get arrested, and then that one act is placed on the spotlight for people to see.
Yeah. Well, let me run through these super chats real quick. They're coming in fast and furious on me. Hiding the lamp. Is Nate afraid of little competition? Throwing shade. That is great. Hey, listen, this is Nick Lamar Suter from End Time. Check out his channel. Somebody can please throw the link in for End Time. Great channel. He does a lot of great stuff. I think they were trying to get you on last night, Kirk. So it's a great guy, great channel.
I didn't see that or hear that. So this is the first I'm hearing of it. So I wasn't trying to ignore them. So my apologies.
I'm going to hook you up with Nick because Nick is a good guy. He was looking for another because I couldn't do it last night.
I also missed Viva last night when he was trying to message me. So apparently I missed things last night. So no disrespect to whoever was trying to message me. We'll try again.
That was my man Nick Suter. But thanks again, Nick, for the $5 super chat. These things is like sometimes they get hard. All right, so this is Christina Ray. This is our super mod. Here's to the three horsemen of the My Sharona Cyrus. I like My Sharona Cyrus better than COVID-19. Thank God you can say it now. But I like it. I say My Sharona Cyrus all the time. I hate you, Viva.
Someone told me it's become an alternative term for the virus, which would be very flattering if we've actually created terms like My Sharona Cyrus and vlog. That would be great.
Grammy, I hope I'm saying Grammy Pace, right? Did you read the medical examiner's report written to help the bad cop? Yes. But we'll talk about that. But I want to try to stay on it. But it was a very interesting play. We may speak on that a little later. Angry, thanks for the $5 super chat. Angry Roach, Nate's lamp was arrested for throwing Molotov cocktails. Just right. And now it's going to get its license taken from the bar. Thanks, Angry Roach, for the $5. Here's Bunny. Officers of the court held to a higher standard. Yes, we are. For instance, there's a lot. One of the more interesting things is that if you're an attorney, you're not supposed to be able to tell a lie in that capacity, but you're able not to answer the question. So if an officer asks you something, and I'm not supposed to lie to them, but I don't have to answer the question. So there's some ethical guidelines, but that's a very good question. Thank you for the $2 super chat, Bunny. Great question. This thing jumps like crazy. All right, $5 super chat from Canadian, from Chet Chisholm. Would you guys be able to discuss the law surrounding duty to rescue later in a live stream? Interesting topic. This is a topic they're throwing out for us. What do you guys think?
Sure, why not?
It might be short from our end. In Canada, it is.
$10 super chat from Ronan Shelley. Take my money. I am going to take it. Thank you for giving it, because it will be taken, baby. It's taken right now. Thanks again for the super chat. There are two others that are not coming. All right, Tatted. Tatted is saying, thank you, Tatted, tossing a coin to the lawyers. Thank you. Nate's Lamp 2020. It's running for president.
And the last is pretty qualified at this point.
The last super chat. Have you guys seen the Egyptologist instructing on how to take? Oh yeah.
Yes. Someone tweeted 11,000 words. University of Alabama, I think it was, on how to take down the Washington Monument. Well, this is what they decided to do. This is a good thing.
It's not rocket science. I don't need an Egyptologist to tell me how to take down a statue. I can figure it out on my own, and it just takes some basic common sense and geometry skill.
That's just give me a truck, some dynamite, and a good alibi, and I think we'd have a good chance. And this is from Dogbert. What is the law on open carry, unloaded shotgun rifle in NYC? Is it legal? Is it not? That's me giving legal advice about something that I think I know the answer to, but I just wanted to stay away from that. Let me look it up and then ask me that question later. Thank you, Dogbert, for the super chat. All right, so now let's get back to the story, because we have been super chatting it up. And it is time to get back to this. But go ahead, Viva.
Okay, I was just sticking my feet like, the author's name is John Ronson. So you've been publicly shamed. It's so far the best book I've listened to in a while. Who's taking bets that these two lawyers are going to be disbarred in short order?
Well, hold on. Let's do this. Let's look at what they did. Because right now I think it's good to look at the charges, because we've been talking about it like they're guilty, but we haven't discussed. We haven't told everybody what they actually did. So let me just go through it real quick. Is that cool?
Well, absolutely. Do it.
All right, so check it out. All right, so let me just present it so everybody can see what we're talking about. All right, it's not working. Oh, I took it off. There it is. Okay, here we go. All right, so this is what these two lawyers did. They, law enforcement, where is it at? Okay, so after finding an NYPD vehicle, Rahman is accused of getting out the passenger side front door of the minivan, approaching the NYPD vehicle, and lighting and throwing a device containing a glass bottle containing incendiary chemicals or a Molotov cocktail into the SUV. Thought a previously broken window. The Molotov cocktail set fire to the console. Rahman then got back into her minivan and drove off, authorities said. Instead of using their privileged position, blah, 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 blah. Now, the NYPD, the incident was caught on surveillance cameras, and law enforcement who saw the incident followed the minivan and stopped it a short time later. And this is the driver, and this is the person who threw the Molotov cocktail. Later, they found Bud Light bottles, toilet paper, and gasoline, so they can make more Molotov cocktails, and they were trying to hand them out. So these are these two lawyers, and that is what they're accused of. And they were arrested and now this is in federal court. Now they also have charges in state court for some other charges, obviously, for trying to destroy public property and harm police officers.
What's the federal hook?
I'm not sure, but this is all in federal court. This is a federal magistrate judge. So I'm not sure what the federal charges. I'm thinking it may be domestic terrorism.
Or that, or maybe weapon of mass destruction, because how broad the weapon of mass destruction statute is written. So maybe being charged with weapons of mass destruction, that'd be good. Because this is, again, it's a federal magistrate judge. So this is federal court, and so they still have state charges. So these two lawyers have a lot to go through. I think at this point their license is no more, right? Their license to practice law is obsolete. What do you guys think?
Yeah, I don't think
they're both getting convicted felonies and going to jail.
Well, if I'm setting aside that, I don't think they would, if they get a conviction, I mean, it'll be the easier form of disbarment, but they don't need to have a conviction in order to be disbarred. So, I mean, even participating in that, I don't even think if they get exonerated or acquitted, it would change much as far as the professional sanctions that they're going to suffer in the immediate future. It is tragic. I mean, if I'm taking the judge's, sensitivity, it is tragic that these people who've worked, for however many years to get to where they are, I don't even care if they got swept up in the moment. I have no doubt that they did, but bad decisions. I mean, they're just lucky they didn't actually. What happened if they killed them?
Viva, I got to disagree with you. This shows a lot of planning. They had bottles, gasoline, toilet paper, handing out Molotov cocktails.
Yeah,
that's insane. This isn't like you're in the middle of a protest and you find a brick and throw it through a window. This is somebody saying we're going to go throw Molotov cocktails at a protest. That's what this is.
But I mean, that level of planning is day of planning, where these people, these two individuals. When I say get swept up, I mean in the movement that has been building for the last week, where they've had time to ruminate and get angry and think that this is the way that they're going to fight, the issues that they have framed in their mind. And you see it from her shirt. It's just it is tragic, because within a day they will have ruined a lifetime worth of work, where they could have actually done more to help the cause that they ostensibly or purportedly want to help, as opposed to undermining the cause and destroying themselves in the process. Can you just imagine though if they killed the officer in the car or somebody else? I mean, it would be they're lucky that it's only this bad.
but they're also going to get implicated for any Molotov cocktails they handed to anyone else and anything they did with them, because they're directly responsible for it. So for all we know, one of the Molotov cocktails did kill someone. So their criminal liability has no end in terms of this. Ironically, or I don't know if it's ironic or not, but the greatest criminal liability probably comes from handing out Molotov cocktails to others, because you absorb all that responsibility. So that's where they're really going to have a problem. But they're looking at very serious charges here. I think you can squeeze into a weapon of mass destruction. I don't know if these federal charges will ultimately live for long, but what they did, at least in terms of burning vehicles, arson. I mean, charge them with arson and furtherance of terrorism. I mean, they're going to jail forever. So take your pick of which criminal charge is going to send them to jail forever. Will it be the weapons of mass destruction? Will it be the arson and furtherance of aggravated arson for mind damages? Will it be handling it to other people who did things? Find out later on our next edition of Dragon Ball Z. That's where we are.
As opposed to doing the Robert Barnes type thing, or what other lawyers would do, which is fight for civil rights in the court system, because that's actually where you can make bigger headway.
Which is all the more insane, because these people have a literal license to make the world better. They could represent people who are downtrodden and disadvantaged and help those people. If they feel there are injustices, well, they're in a position to help with that.
They made Molotov cocktails.
That was not what the Bar Association had in mind. I've been to a fair number of CLEs, and I don't remember the one about how to form Molotov cocktails. Well, the Bar Association meeting. Maybe I'm missing it.
There's undoubtedly going to be people, if late night humor is going to make jokes, there's some pun to be made with.
Is there a CLE in here? Is there a CLE for how to make Molotov cocktails? Because if there is, I want a piece of that.
You guys are understand. Let me hit a couple of these super chat stuff, but you guys are killing me here. All right, this is from Towson Oberlander. Trump calls Nate's lamp a professional anarchist. It is. Be wary of the lamp, because the lamp is a bad guy. The lamp is a bad guy. Thank you for the $2 super chat. Oof, I missed a couple of these. Let me make sure I go back. Okay, so I got that one. Sorry about the super chat wait, but we're getting a lot of action on the chat. I thought I just missed one. If I missed your super chat, please let me know, guys, because I'm trying not to miss them, but I think I have. I missed one. I think I missed a $10 one too. All right, I don't see it. So if anybody remembers or sees the super chat that I missed, or if I missed your super chat, just let me know in the comments and I'll look out for it. Thanks again for all the super chats too. I really appreciate it, guys. Okay, so now I would suspect that all of us know and believe these guys aren't going to be they're not going to be lawyers after like today. I actually looked them up on the court's website. They're still listed as attorneys, but that's like done. Like as soon as something happens, that's going to be done.
They could surrender their license and save everyone time. That'd be
yeah. This is Nick. $2 from Nick Studer. Could easily have set themselves on fire too. That's true. They could have easily set themselves on fire. But I think the professional responsibility piece is just awful. But now moving on to our next crazy story. Well, not really a crazy story. This is the religious freedom issue. Now, it's funny because a lot of times you think when the facts come out about a particular situation that it is simple, that, we the facts drive the legal conclusions. But in this case, it seems like we're all looking at the same facts, but come to varying different conclusions. Now, I want to just make sure we know this is a recent case ruled on by the Supreme Court, South Bay United Pentecostal Church versus Newsom, which is the governor of California. And just to TLDR, so we can just get the quick rundown, the church in California, they're opening it back up. And the issue here seems to be whether the regulations that allow churches to only have 25% capacity is constitutional, while other businesses and venues are allowed to be at 50% capacity. So it's trying to so the court is trying to figure out, is the restriction on churches, which is a little bit more stringent, 25% capacity, is that constitutional? Are you now inhibiting people's freedom of religion versus these other businesses, like I think they were saying pet shops and some other things? So the court in 5-4 ruling, Justice Roberts, the Chief Justice, he wrote the opinion, and he says he joined the liberal justice and says no, these regulations are constitutional and well within the guidelines of the Constitution. While the dissenting, it's really 3 justices who signed under Kavanaugh's dissent, said that it's obviously not, and that you're discriminating against churches. So he respectfully dissented. So what do you guys think about this case?
Nate, have you got a copy of the decision itself that you're able to pull up?
Yes. You want to pull up the decision?
Pull up, because it's on page 1 again. There's 2 things reading this from my perspective that actually, and I was mulling it over in the middle of the night, 2 things that actually I find surprising is that you can see the way, and I'm not judging one way or the other because people are going to disagree one way or the other. The majority is comparing the church to similar and dissimilar businesses. And when they compare it to similar businesses, they compare it to movie theaters, concerts, lectures, etc. And the dissimilar businesses to which they compare it are grocery stores. They didn't compare it to restaurants, which I found, nor did they compare it to office space. Grocery stores or the laundromats, etc., where people don't hang around for long periods of time. So the comparison that they use, the majority misses something, because they conveniently don't compare the churches to office space. They don't compare the churches to, what was the other one? Restaurants. They don't compare the churches. They don't compare the churches to other similar businesses where people sit down in close proximity for extended periods of time, which I found interesting. The majority decision also in the intro says it doesn't specify that it's 25% of occupancy or limited to 100 people, whichever number is lesser. The minority specifies. So it's interesting just the way that they pick and choose what they want to compare it to. The flip side, because I know people are saying it, is the minority is only comparing the churches to restaurants and office space, and not comparing it to concert venues. And people are drawing a distinction between restaurants and church, which I think that distinction is totally not totally. I think it's a insignificant distinction, because people are saying, oh, you talk more in church, you pray, you scream, you shout, which is a greater risk of contagion, whereas in a restaurant you don't, which I'm not sure about. Restaurants, you got saliva all over utensils and all these things. So it's an interesting, picking and choosing to come to the decision that you want to on both sides, compare it to what you want to compare it to, and then ignore that which you don't want to compare it to.
That's true. What do you think, Kurt?
I think that's what the government didn't show enough basis for their differential treatment in their regulations. And I think they could have, because I think you can differentiate it on a neutral basis, because churches present different situation because of close proximity. People are standing, in your typical church, at least the ones I've been to, I can't speak to all churches, but at least the ones I've been to, you have pews and people standing in a row and they're singing and they're in close conduct, and they're in an close indoor environment. So that might pose some health hazards because of the nature of the setup. Now, not all churches are like that. So you might have to write the regulations carefully. So I think you can differentiate on the facts from a church in a neutral way. You can differentiate on a church versus like a grocery store. And it is more similar to a theater or a sporting event, especially one that would be indoors. Because a sporting event, again, typically you're sitting on bleachers or the equivalent, seats that are in a row. People are screaming, yelling, loud voices. So it is similar enough, that seems to me. So those would be the analogs. But it seems to me the government didn't do a good enough job in its regulations in justifying the differential treatment. They could have got there, but they didn't. And so they were insufficient. So I think that was sort of the problem, that they are treating it without doing the rationale.
Go ahead.
I was just going to say that I think some people are taking a bigger issue with comparing churches to restaurants, as though the right to the free exercise of religion is not something of a greater constitutional right than the right to eat out at a restaurant of your choice. And people are saying, even if it is slightly more risky, which I'm not sure there's any scientific evidence of, than 50% occupancy of a restaurant, this is a fundamental First Amendment constitutional right to practice religion, and so it should be treated with a greater deference than eating at a restaurant.
Right.
Well, two things.
Such as the lemon test is, which is not long for this world. But such as the lemon test is from the United States Supreme Court.
Hold on, Kurt. Let them know what Kurt with lemon is, because
I was about to say, Lemon versus Kurtzman is a case of the U.S. Supreme Court, which has been deeply questioned and probably is going to not be long for this world, but it still exists. So what it basically says in short is that if you're treating religion on a neutral basis, neutral rule of general application is your magic words from that test. So as long as it's a general rule that's generally applicable and it's neutral in its application, then sure, it applies to churches as well. No problem.
Can I say something on that point? One thing I think everyone in the audience should understand is that the Constitution, as written and as the First Amendment, as the courts have viewed the First Amendment, the church is not to be put on a pedestal or in a privileged position, nor is it to be put at a disadvantage. The constitutional restraint is to treat the church just like everything else, and that protection is so you're not advancing the church or prohibiting the church, but just being neutral in the application. So that's what the Kurt is speaking to. I understand that sometimes people, when it comes to religion, they believe that it has this special place, but it doesn't. The Constitution is particularly concerned about treating religion in a neutral way that doesn't prohibit it nor advance it. Go ahead, Kurt.
I would slightly disagree with the way you phrased that, because the Constitution says that you can't establish religion nor inhibit the free exercise thereof. So you are in a position where, presumably, if the government were so inclined, they could, for example, just close down theaters,
yes, I agree.
Sports events at all. So if the government decide we don't like sports anymore, we're not going to have any more sporting events because we don't like them anymore, they could do that, and they can't do that with churches. But so they're privileged in so much as you can't shut down the churches.
I would even disagree with that, which you just said. Because, for instance, let's say if I have a Broadway play.
Sure.
And there've been many cases where people have said, "Oh, this play was, obscene," and then you got the freedom of speech that kicks in. So even if you don't have the protection of the freedom of religion, you still have the protection of freedom of speech and expression, which then you have to go through that test.
Yes,
but
well, maybe I should have picked a different example. But yes, fair enough.
I understand what you're saying, though, but you still have to deal with that.
So, anyways, in applying the Lemon versus Kurtzman test here, I think they could do it as long as they could show the neutral applicability. So, if you can show that the regulations are being done on similar businesses and theaters, yoga studios, these kind of things would be similar in kind, and you can show that you're treating them the same way, then you're probably okay. If you're treating the religion differently, then you're going to have an elevated test. If you're treating the religion differently than the similar situation, then you go from a intermediate scrutiny to strict scrutiny, and good luck with that plan. So you're going to have a tough time.
Well, I honestly disagree. I disagree in application. Like, I think we all are agreeing on the law, but I think I disagree on the application. I think this was actually a pretty good ruling by Roberts, and I agree with the reasoning. The way I'm looking at it, and maybe that might be the difference. I'm looking at it as differently. First, what was the law meant? What is the regulation meant to do? Right. It's meant to do, I think, 5 different things. First, it's meant to regulate large groups of people, right, that gather in close proximity for extended periods of time, and where social distancing, the 6 feet social distancing rule, can't be achieved. So if you think about a movie theater, you have a row of seats and everybody sits in the seat. So let's say if you do 50% capacity, well, that's one every other seat. That's not 6 feet apart, right? One person sitting that's the seat next to an empty seat is not 6 feet apart. It's like 3 feet apart. When I was reading when I was doing research for this, I was like, oh yeah, that's true. It's only 3 feet apart. But if you do 2 seats between everybody, then you can get something close to 6 feet. They say between 5 to 7 feet, but 6 feet is 2 seats in between each person. So if you're talking about, every other seat empty, that's 50%. If you're talking about every 2 seats, now you're at 25%. So the regulation was saying, well, if you have this type of environment in a theater or in a church where you now at 50% capacity, you're not at 6 feet. But if you're at 25% capacity, you're at least 6 feet apart, because if everybody just sits down in the row or whatever, then that's why they were limiting things like, lectures, movie showings, sporting events, theatrical performances, because they all had this similar problem where, you couldn't just sit everybody at every other seat. That's 50% capacity. So now the church was arguing, well, we are just like these other things, right? Group 2, which is factories, offices, supermarkets, restaurants, so forth. But even in restaurants, everybody's not just sitting. It's some restaurants, but most restaurants, you have tables. And when you look at it, if you just say, all right, I'm not going to do half the tables, then you still can have that 6 feet distance. And let's say a supermarket where it's not everybody standing next to each other, but people walking around at 50% capacity. So I think if you just look at the law as it was intended to be applied to the situations, then I think, yes, churches are more like lectures, movies, spectator sports, and theatrical performances, and have those same limitations. That's why 25% for those. And they're not like grocery stores and these other things. And I think the law, as applied to this situation, makes sense. And I think the Chief Justice made the right call in saying, if we can't, there has to be some give and take. And churches, we're saying churches are like these other particular events, and we're going to allow California to restrict them just like these other, because of the public health crisis.
There's one other notable detail about the decision because of the posture of the case that we haven't discussed yet. This was on a motion relating to an injunction. So there's a technical aspect to this that's important, because injunctions are not given as a matter of right in the United States. They're considered an equitable remedy. Yeah. And so they are never afforded as a matter of right, and they have their own separate analysis. So this is different than a decision on the merits. So it's not the Supreme Court analyzing it on the merits of the case and reaching the ultimate merits conclusion. It's technically different. They're reaching the issue on the injunction, whether or not the injunction should be issued. Apparently 4 members said, yes, we should issue the injunction, and 5 said, no, we shouldn't issue the injunction. But that doesn't necessarily mean that if this came up through the system and the Supreme Court heard this on the merits, you would necessarily get the same result. Because a person could differentiate this on the injunction issue versus the ultimate merits issue. So a judge could, for example, not issue an injunction, but ultimately rule in your favor when they get to the actual merits of the thing. And that wouldn't be unheard of in a trial court situation except to do that.
Go ahead, Viva.
The last sentence of the majority decision says, the notion that it is indisputably clear that the government's limitations are unconstitutional seems quite improbable. So, I mean, they're indicating which way they're going on the merits, even though it's only at the injunction stage, and they explain why they grant the injunction. But
at least for those 3 members, yes, I think that they're definitely indicating where they would line on this. I'm just saying in terms of trying to where like Roberts would be, or in terms of where someone else would be, you don't necessarily know where they would necessarily be. So it could be that because of the procedural posture and because this is an expedited review, because of the nature of it, that's why it came out this way.
Yeah, so it might also it might take a more clear-cut case, even though I tend to not agree that they're comparing comparables in this decision. But one thing that struck me, I don't know if anybody's read it, but I'll read it out loud. It's page 2 of the majority opinion, where it says the precise question of when restrictions on particular social activities should be lifted during a pandemic is a dynamic and fact-intensive matter subject to reasonable disagreements, et cetera, et cetera. And then they cite Jacobson. Which Jacobson was the smallpox issue 100 years ago. Then they say this, which is what got me up in the night. When those officials, quote, undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad. Marshall versus the United States. I haven't read Marshall, but one thing that struck me is like, in the moment I'm thinking, in areas where they're fraught with scientific uncertainties, that the power should be more broad and not more restrictive. It to me seems counterintuitive. So not knowing what was actually said in Marshall, what they're effectively saying here is, if they know for certain that, it's extremely, if they have scientific evidence confirming what needs to be done, then, and even if it's unconstitutional, prima facie, it can be justified. If they have scientific certainty that shows that what they're doing is not helping, then it will not be unconstitutional. Then the unconstitutionality will not be justified. But in the middle, if it's fraught with uncertainty, we need to give them even broader application of powers. I mean, that seems crazy to me, because that seems like we don't know anything. Therefore, our powers to impose potentially unconstitutional restrictions is therefore much broader and limitless, which seems counterintuitive. And I don't know what Marshall says on the merits.
Yeah, I kind of go the other way on that one, because the way I'm reading what you're telling me is we have a zone of uncertainty. So if we think about the total range of things government can do for all the things, their total range of options, given all the possible situations, right? If we know for certain, if we have more scientific certainty or factual certainty or whatever it is, we know more within the zone where we're going to be, and perhaps exactly where. So we know, okay, we're exactly here. This is exactly what the government can do. We have it defined. But if we're more of in a situation of uncertainty, the total range of what the government could theoretically do in all possible situations, right, isn't as constrained. So maybe we're like in this zone. So we're like, well, we're somewhere in this zone. We're not exactly sure we're in this zone. So we need to give the government the latitude, because we could be over here. So this would be unconstitutional over here. But over here, it'd be constitutional. We don't know. So we're going to give the government all the power to the most extreme limit, because it could be that, and we don't know. So the fog of war gives the government power to deal with the situation. And this is also why I said in live chats with you guys on the past, I said 2 months ago, for example, I've said very deliberately, it was legal at the time and won't be necessarily legal in the future. This is legal today, saying that 2 months ago, but might be legal tomorrow, for exactly this reason. As we learn more and more about this COVID situation, for example, and more about what's going on, we can more and more tailor the situation. And so the government's power necessarily becomes constrained. So that's exactly why it was constitutional 2 months ago and may not be constitutional today, because the factual certainty is narrowing this gap. And now we're like, oh, we're in this much narrower range, so we know a narrower limit of what the government can do. So to me, it makes perfect sense.
Oh, Nate, you're on mute. Mike.
Yeah, sorry. This also goes to the administrative procedure piece of it too, because the court feels, and even reading through this case, the court feels that it doesn't have the expertise in this particular area to say, like, these are working and these aren't working. So in that evaluation, it's kind of saying, well, we're the experts on the Constitution, but we're not the experts on epidemiology or whatever. So in that sense, if the experts are saying you should do this, and the experts are saying that this is going to save lives, then at what point can we make an evaluation? Even though it's a predictive model, it's just like, okay, if we're wrong, then it's going to be us unelected judges who, are not accountable to the people, going to be responsible for killing 2 million people. So they're saying, well, that should be, and it even says that's more of a question for the political branches, because they have to be accountable to the people at every certain time. And since they have to be accountable, if they're wrong, it may be constitutional today, but if they're wrong, they get voted out, and then we can make the determination when we have more facts that it wasn't constitutional not to do it again. And I think the case you run is Korematsu with the Japanese internments. At that time, it was like, okay, the fog of war, these people could be doing this. It's constitutional, but now I think everyone knows that wasn't constitutional. Because
that's where I split from Korematsu. Even the fog of war didn't give him that much in my
that's
where I thought they got it wrong.
I think they got Korematsu wrong too. Go ahead.
Yeah,
says you, Kurt, but in an area fraught. Well, let me just get the words again. Fraught in areas fraught with medical and scientific uncertainties, they have more power. Well, I'd say in 1940s World War II, it was so fraught with uncertainties, just lock everybody up, lock everybody who looks a certain way up.
Yeah, that's really
my problem is with this. I'm predicting it now. This exact same justification can be used mutatis mutandis for global warming issues. And what the government's going to do, it's fraught with uncertainties. We don't know, so we better just do everything, because otherwise, some experts say 2 million people are going to die, and some experts say 50,000 are going to die. Fraught with uncertainty. Let's just expand our powers, and the judicial branch is not going to keep us in check. It's going
slippery slope.
This reasoning is going to be used later on in circumstances where we are not going to like it. It's not a question of having narrowed the range and picked from a broad, not broad, but rather we've narrowed the range and picked the appropriate narrowly tailored measures, which is actually the criteria. Here it's fraught with uncertainties, broad as you want, to do whatever you want, even if there's no scientific certainty that 6 feet is better than 5 feet, or 5 feet is not worse than 6 feet. It's You're gonna hear a kid making noise upstairs.
It's all right. My kids are making noise too. So.
Oh, it's nap time in 15 minutes.
I appreciate what you're saying in terms of being cautious and cautious and jealous of liberty and cautious and jealous of what the government can do, because you're right. The people can use excuses to do things that they wouldn't otherwise be able to do. And this is a classic just problem of balancing things from conservative and liberal principles, left-leaning and right-leaning principles. It's like, well, the exceptional case is exceptional. So we need to do things that are exceptions in the exceptional case. That's why they're exceptional. So the exceptions apply in the exceptional case. But the idea that someone could apply the exceptions in the non-exceptional case is always a problem. Incidentally, this is like one of the problems that I run into sometimes with people when I'm having debates with them. They try to use the exceptional case to prove the ordinary case, and you can't do that. You can do it the other way around, but you can't do that. So, a police officer can use force against someone. You're saying a police officer can fire at someone with no cause from 5 feet away? No, that's an exceptional case. And you're using the logic of that to prove the ordinary case, which you can't do. But yeah, constraining the exceptional to the exceptional is a problem.
Well, I do want to say
the way we solve that,
go ahead.
We tried to solve the problem. The way we tried to solve that problem was with the balance of powers and the separation of powers. And this is what Scalia talked a little bit about when he talks about the Constitution. Well, I'm paraphrasing Scalia now. He says, what is the Constitution? When you talk about someone's Constitution, you talk about their structure. And so the actual Constitution as such is the structure where the balance of powers and where power is jealously guarding power. Well, and so that was his idea.
Well, I agree with in part, but I disagree in part. It's interesting because I do tend to agree with Viva more on this point, because I do think at a point the government does overreach for authority. And you're right, this is an exceptional time, so you do have exceptional measures for this particular thing. But the stare decisis, the next case that's going to cite this is going to cite it, I think, exactly the way Viva is saying. We have uncertainty. This guy says 7 feet. This guy says 5 feet. We just made it 10 feet to be sure. And since it's and that type of thing, and then people will say, well, look, you allowed us to do it in this case. Now, this is not as exceptional as this, but here is the precedent that allows this to happen if the court so deems it to be. And I think if that's the case, I think Viva is right in that case, is that now that you do have this precedent saying that you could do this does, and you got to agree, Kurt, that this expands government authority tremendously until the court now comes down and curtails it, until it says, okay, that it's far enough. That's far enough. Right now, it's extremely broad. Go ahead.
It expands it, and it sanctions in the tolerate sense constitutional infringements in areas fraught with uncertainty. So you know darn well that someone's going to cite that in any global warming case. Now, it is fraught with uncertainty. The numbers, they've predicted millions they predicted whatever by 12 years left of the earth. How much more dire can it get than that to justify whatever? And then the other problem is, it seems to me that the more information that the world gets on the virus, in this particular case, the more information they get, the stricter the rules get, and not the other way around, which is it's that lose-lose argument where, look how well it's working, let's get stricter and stricter. And I don't know if you guys follow, well, I'm on Twitter, but I retweeted this Edmonton mayor tweet where he says, they have 50 cases in Edmonton, 5 people in hospital, 1 million people. The tweet was, we're doing good. We're going to extend we're going to extend the, whatever they call it, the emergency orders. And because he didn't say because, but he says we're extending the orders. Many people are complying, but compliance is not at 100%. And it's not a slippery slope. It's just inevitable. And that particular phrase in this judgment didn't strike me as a slippery slope. It struck me as exactly what is going to be cited when there is legislation that is deemed to be or challenged constitutionally justified on the basis of climate change or global warming.
I appreciate that is a risk, and I appreciate your alerting to the risk. It's a little unclear to my mind what is the alternative, though, because presumably we need to be able to deal with emergent situations and ones that are unknown, and need to be able to deal with situations that are exceptional and unpredictable. Because depending on your point of view, one of the things the government should do, or perhaps the only thing government should do, is to keep us safe, keep us free, make sure that we can live our lives. And all that good stuff. And so so to the extent that any disease, for that matter, is a true existential threat, it's an existential threat just like any other threat, whether it's an invader or whatever. It's an existential threat to that system. And so the fundamental point of government is to keep us free. And if there's an existential threat, they need to fight that to keep the liberty. Now, I am somewhat encouraged by the history of the United States on these things, because I think for the large part, we have responded in exceptional times with exceptional measures. And then when things became non-exceptional, we've come back. Of course, that hasn't always been true everywhere in the world. I'm looking at you, Caesar, who decided to hold on to your emergency executive powers to the point that, the entire concept get named after you. Way to go, champion. So yes, there is a fundamental problem, but what's the alternative? To constrain things in such a way that you can't deal with the emergent? It seems impossible. Well, I'm conservative, but I do want to preserve the society, so I need to figure out a way to balance these risks.
So, I have two. My issue is it's not a question of conservative or liberal. It's a question of the criteria being, to justify constitutional infringements, the restriction has to be as narrowly tailored as possible.
Right. Sure.
That's fine. That is the diametric opposite to saying in areas fraught with medical uncertainties, the government's power is broad. I mean, these are two, as in my mind, mutually exclusive arguments and mutually incompatible arguments to justify the same constitutional restrictions. I don't know how to do it.
This Viva and I are just going to disagree on this one. That's okay. We can disagree. But if you say narrowly tailored, I say narrowly tailored to what is exactly the problem. And the problem exactly is the uncertainty. So we don't know what we're narrowly tailoring to. We may have some ideas. So so again, in the range of everything government can do, to say that we have some uncertainty is not to say we have all uncertainty. But it is to say that the nature of the situation, when we're narrowly tailoring it to a wider range because we don't know. Now, a person could misuse this idea when things are more well-known to say, well, since I could do it in this case, I can do it in this case, but that doesn't work around. If you can do it here, you can do it here. Well, but just because you do it here doesn't mean you can do it here. It doesn't work around.
Someone's going to accuse you of lawyer talk, narrowly tailoring it to a broader range.
all dogs are mammals, but not all mammals are dogs.
No, this is true. But first of all, Nate, can you take? If I'm predicting something, you have a child spoon in your cup of coffee. Do you?
Yeah. Yes.
That's it. Okay, there we go.
Noted. That is a thing that occurred.
I like it because it's small enough where I can mix everything, and it's just easy to wash too. It's like perfect for me. It's
you are an adult. You do you, man. I have your back. Viva over here criticizing you about this child spoon stuff, man. Viva, why are you conservative? Stay out of his.
I am proud of my child spoon. My child spoon. I'm proud of it.
But you believe in individual rights, Viva. What's up with that?
Well, listen, but before we run out of time, because I think we only got like another 5-6 minutes. Let's move to the last case, because because to be honest with you, I agree with both concepts. I think Viva's 100% correct. People are going to use this for global, you're going to be able to use this for global warming for sure. Like you just obviously that's the language. That's the language I would use. And I think you're also right too, and Kurt's also right too, where exceptions. You have to have a situation where you have to give more leeway. So, but again, this is why they have lawyers. And this is why they go and sue. And this is why they go to the Supreme Court to find out where those boundaries are.
And the expression "bad cases make bad law," so you don't take
very true.
Cases.
Very true.
We can all agree on that.
Well, let's move to our last. Hold on. Let's move to our last little issue. Let me move this. I got to dump this. Now, the last one is Trump's Insurrection Act.
I'm sure we can discuss this in 5 minutes. That sounds like a thing that's going to happen.
All right. So you know what? So
Kurt, I don't mind taking more time.
Kurt, you've done the research, right? Into the insurrection.
Yeah, I did a little bit.
I was going to do a TLDR. All right. So just give us the quick 2-minute breakdown of what it is.
All right, so your quick breakdown on what it is. All right, the Posse Comitatus Act, which everyone loves to refer to, says in substantive part that it doesn't apply. If you want to write, okay.
Yeah, no, he's coming right back.
The Posse Comitatus Act says in substantive part that it does not apply if there is authorization somewhere else in the Constitution or some other act of Congress. So it's not Posse Comitatus if it's in the Constitution or an act of Congress. So you have two different possible authorities to do. Article 4, Section 4 of the Constitution provides the U.S. government shall provide to each state a Republican form of government. And upon request of the state legislature or the state executive, the United States government can send force to quell civil unrest. So that's upon a request. However, there's also another authority. There's the Insurrection Act, which is 10 USC 253, I believe. But anyways, it basically says that the president of the United States can use either the militia, meaning National Guard, or the military, or both, or any other resource to quell an insurrection, an uprising, or civil disturbance in any state where that is causing where it's causing a civil unrest, where people's rights are being infringed. So long story short, yes, the Posse Comitatus Act does not apply because it all on its own terms has an exception for any act of Congress, of which the Insurrection Act is.
Yes.
So you can deploy U.S. military forces, active military forces, National Guard, or anything else under the president's control to bring back in the control. So yeah, you can do that.
Well, not knowing anything here. I'm just looking through it, and I just want, for my own curiosity, how many of these presidents were Republican versus Democrat?
Well, actually, Democrat, Kennedy's Democrat, Eisenhower's Democrat, Roosevelt was Democrat, Woodrow Wilson Democrat, Cleveland.
Well, hold on, Eisenhower was a Republican.
Okay, yeah.
Eisenhower's a Republican, okay, and George W. Bush, the Bushes are both Republicans.
Okay, yeah, so most of them are Democrats.
But just to clear, but just a couple of points. The first point is, yes, this is an exception to the other act that restricts the government from using military force for law enforcement actions. But there are two pieces to this. Now, the first piece is whether the state can request the help from the federal government. Now, when it comes to Washington, D.C., Trump can have federal troops go inside there and start doing stuff now, right? Because that's a federal district and the control of the federal government. There is no state to give approval to. But when we're talking about now using military forces in particular states, generally the act has there's two ways you can do that. One, the state can request it. And as you can see from this list, so Wikipedia, it's not a full list. But as you can see, most of the times when this act was used, it was requested by the state governments. But you'll see times here where the state did not request the use of military force for this action. And those specific examples are things where the federal court, the federal government is trying to enforce a federal court order. And as you can see with the Dwight Eisenhower, John F. Kennedy, and Lyndon B. Johnson, those are all those civil rights issues. When let's just state like Alabama didn't want to desegregate public schools. So the president sent the army just to enforce the court order. So that's one way you could get around it. But here, obviously, Trump doesn't have a court order to enforce. But that's one way you can get around state. But generally, it's required that states approve. States have to request it, and then the president can send troops. Now, it's interestingly enough, recently, George Bush, I'm not sure if it was 41 or 43, asked for the law to be amended. George Bush asked for the law to be amended to remove the piece where states had to request it, so he could just send them. And all 50 governors from each one of the states sent a letter and rejected that and says no, because what it have the effect of doing is allowing the federal government to send military troops to occupy states. So all 50 governors said we don't want to do it. Republican, Democrats, and it doesn't happen. So now the question is, does Trump have the authority to use military force to stop these quote unquote insurrections, or would it be unconstitutional?
Well, the way the statute's written doesn't seem to be a problem. I mean, states can certainly request it under Article 4, Section 4, but the way the statute is written seems pretty broad. It doesn't seem to require states to request it. I'm sure states have requested it, but it doesn't seem to be anything there that I saw.
Because that's what the argument is now. Can Trump just send federal military? Because if he does, he's breaking the what's the other act? The Posse
Comitatus.
Posse Comitatus. But the exception is this, and this is if you're saying that Trump doesn't have to ask for approval, then the Posse Comitatus Act really is what is it there for? It's obsolete, right? Because insurrection, I just send federal troops.
Well, I'm just going to pull up the statute on my screen real fast so people can see what I'm reading. So this is 10 USC 253. This is the statute that would apply.
Screen shared, and I'll.
I'm doing better than that. I'm just I'm doing it. Okay, I was doing it within OBS so people on my own screen can see. Sure. But hold on one second. Okay. Shoot.
No, just read it. It's fine. Just read it.
Screen share. I can make this work. Screen share. Select Windows screen.
I had to pull out my camera. Now I'm using my computer camera, which is why the quality is so much worse, because my kid needs the computer, needs the camera for Zoom classes.
I can't figure it out. I'm sorry. I'm just
no, don't worry. Just read it. Just read it.
So this is 10 USC 253 is the statute, and here's what it says. The president, by use of the militia or the armed forces or both, or by any other means, shall take such measures as he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combination, or conspiracy, if it so hinders the execution of the laws of that state and of the United States within that state, then any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and secured by law, and the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, immunity, or give the protection, or opposes or obstructions the execution of the laws of the United States or impedes the course of justice of those states. So rephrasing what that just said in so many words is that you have to show that the civil authority of the respective state has failed. So that is a condition precedent, that the states are unable, fail, or refuse to give the aid. And as I said, Article 4, Section 4 of the Constitution says that the federal government shall guarantee to every state a Republican form of government. And then it's some other stuff. But presumably Congress, under the necessary and proper clause, could also give some authority to what that would mean. And so to guarantee a Republican form of government, well, among other things, it does not include rioting and civil distress in the streets. It requires elections and all that stuff. So I think there's nothing in this language that I just read that requires a state to request anything. So I don't think it renders posse comitatus moot. It's just that there's some conditions in here that would typically not apply. He can't do it for any reason. He can only do it if the civil authority has failed, and which may be the case in some relevant jurisdictions at this time.
So let's take that premise and use it. Let's say you're 100% correct. Have we reached that point? Is what we're seeing now on TV, has that reached that point?
Well, that's debatable, Phil. That's a little bit of a debatable question. I think in Washington, D.C. in particular, it was getting pretty ugly. When they tagged the World War II memorial, that was the point that the people lost all sympathy I had at that point.
But that's not insurrection, though. That's like
That's the straw that broke the camel's back.
It's wrong. It's horribly wrong.
Yeah,
but I don't think somebody tagging the World War II memorial is an insurrection where you can start.
No,
even though it is Washington D.C. and you don't have.
There were other things about it that made it more insurrection-y. I was just saying that was the thing that broke it for me. I was like, that's one thing too far. That's a bridge too far. But yeah, do we have states that are unable, fail, or refuse to protect the rights, privileges, or immunities, such as protection of property, as a fundamental right, which again is a fundamental right, the right to property. But do we have state authorities failing to do that? A little bit. It's some places where this is happening, and the federal government has an interest in. I
would imagine.
I don't know.
So I know nothing. I know nothing of this law. I would imagine it's going to be a question of the scale on which that's happening, because not protecting property happens every time that a crime doesn't go investigated, type thing.
Sure, of course.
One thing I can. As the external guy, the Canadian, one thing I can tell you is no matter what Trump does, one way or the other, he will be blamed by one side and credited by the other. Period. Yeah, so if he does nothing, I suspect the Democrats are going to complain that he's not restoring order. If he does something, they're going to say he's encroaching on the what's the word I'm looking for? Sovereignty of the states.
Yeah, they'll throw the state rights argument, which is always great because it's a classic Republican talking point. What about the state rights, Trump? What about that?
One thing I don't want to miss. Well, let me throw the super chat from my man Dragnet. This is my brother. How does tagging the memorial invalidate a movement? Interesting question. I don't think it does. I think some idiot went into, just like the two lawyers who throw in Molotov cocktails. But I don't think it invalidates the movement. I think what it does is it's that there are people out there.
I think it does, to the extent that the movement doesn't try to police its own side, because I think bad actors on your own side make your own side look bad.
But how do you police?
Well, for starters, by condemning them openly. If you're any part of any organization that is trying to put together organized protests and marches, then my recommendation would be openly condemning them and disavowing them.
So all right, so let's stop right there. they've done that. You know, the brother has come out and done that. Killer Mike has come out and done that. All the people who have who are supposedly the leaders of, let's say, BLM, Black Lives Matter, they've all come out and said, this is wrong. We don't support this. You know, there's videos among that. So all of them have said this. Now, you do have some bad actors, like these two lawyers. They're just bad actors who go out and throw Molotov cocktails and are not involved.
You shouldn't talk about Viva and me that way. No, we meant the other two lawyers.
Well, no,
yes. You understand what I mean? So somebody tagging that may have nothing to do with even the movement itself. So it could have been some random kid that just went and did that. That's what I think the argument is. It's just like, yes, people do bad things in all spaces. So
yeah,
you know what I mean?
This is also classic false flag. One of the reasons that you would false flag is make your enemy look bad. You put on the uniform of your enemy and you do things in their name to make them look bad. It's a classic tactic of negative propaganda. So you pretend to be the enemy and then you do things in the name of that enemy to make them look bad. That's what's called negative propaganda. So yeah, you can do that too, but it is a problem. So I don't know who's organizing the things in DC, whoever that would be. I don't know if it's organized, which also makes it a bit of a problem for unorganized movements because there's no one who really has the authority to stand up and disavow this thing.
Let me let Viva get his side here.
I think Kurt means it invalidates the movement as a figure of speech, whereas if the movement itself becomes characterized by antithetical violence, then yes. But this I think is there's a legitimate movement under here. There's a legitimate grievance. But yes. Nobody's denying that. And then flip side, by and large, nobody's denying that looting is not part of that grievance and it's not part of redressing that grievance. And yeah, you just have bad actors within who are opportunistic parasites that seek to just cause havoc and I don't want to use the word hijack as it's a loaded term, but parasitize an otherwise legitimate movement. And to Phil James does the delivery of bricks before protest. There's the movement itself, and then which gets out of hand once people who are not there to support the movement but rather there to infiltrate it bring bricks. Once people start throwing rocks, I guarantee you most of them don't know where the rocks are coming from, but when they're being brought in by outside entities that have nothing or little to do with the movement, that's what you call hijacking an otherwise legitimate movement with illegitimate conduct.
It was suggested that members of Antifa were also placing fuel, gasoline, and other things in various locations in anticipation of riots. And it has also been suggested that Antifa is trying to hijack Black Lives Matter, which definitely seems like a thing that's probably happening, which also incidentally is another scorn on Antifa because they're taking away the legitimacy, again, of Black Lives Matter because they're trying to adopt that and make Black Lives Matter look bad. So it's hurting their legitimacy.
Well, first, let me thank you, Phil James, for your super chat. Viva read it out for me. does delivering brick, and I think you're right. I think I think you guys are both 100% correct. Angry Roach for $2. I think it means have your guest even read Draper. They haven't. We're not talking about the definition of that word because that word is a demonetizable word all of a sudden.
I have no idea what you're talking about. So this is off.
It's an inside joke about a definition of a philosophical word that I've been having that we've had a 4-year war about.
Ooh,
but the war is over. The war is over though.
The more important.
What is your answer so that I can disagree with it and bring it now?
Have you guys? Have you seen the video of John Jones taking spray paint cans away from? It looked like outside actors of the protest.
Yeah.
No.
It's amazing. I mean, it's just amazing. Everything about it is amazing in terms of context, in terms of demeanor. I don't even know if the people knew that the person removing their spray paint cans was John Jones, like the most dangerous man in UFC. But it was on Twitter. It was good. I mean, it goes to show you that there are people, brave people, and also people who want to maintain the integrity of the legitimate grievance as they see it. And it was on Twitter. If you look for it, you'll find it. It was an interesting video.
Hey, have I been missing? I think somebody's put members. Have I been missing members? Have I gotten some new members?
I'm concerned about how things are going to be developing in the near term because we have an election 5 months away. So I'm concerned that where this is going and how the election and how the results from that will impact things going forward. I am somewhat mollified by taking note of things that occurred in, say, the 60s and 70s. And some of the riots that occurred in that time frame, and some of the stuff the Weathermen did, and some of the stuff Black Panthers did, and other groups that we are not quite in that territory. So I still have some hope that this thing is going to be ultimately resolved in a way. But I have concerns about the fabric of the country and things like that because I'm conservative and I see threats, and I'm not a thrilled guy. And also on a personal level, I saw what I personally observed. I can only speak to what I personally observed, but I live broadcasted from the protests that were occurring in Austin at 8th and I-35 on 3 different occasions. I went down there at 1 p.m. local time, about 4:30 local time, and 9:30 local time to check and see what things were going on. And at least as to what I personally observed, I saw the police acting fully reasonably. Now, I'm not saying the police are blameless. I'm not saying they didn't do something somewhere else. I'm not saying I saw everything. At least to what I personally saw, though, they seemed perfectly reasonable. They were very restrained, very professional, and they were only deploying force on a very judicious basis. For example, on Sunday, there were a bunch of protesters standing on the interstate, blocking the interstate, which is illegal. What did I observe? I saw a police helicopter in the air going around for about 15 minutes, broadcasting, people on the highway, you need to leave, they need to leave, you need to leave. And then saying, if you don't, we might use gas, saying this for a couple minutes. And only after about 15 minutes of this, then did the police finally use force. To me, that seems fully reasonable. And that was consistent with everything I saw. Now, apparently my fellow Austinites are not pleased because I've been reading the Reddit on Reddit Austin, and they are not a happy bunch of campers. They think the police are brutal. I'm like, I don't know what you're seeing, but at least what I'm seeing, I didn't see that. So it's a very weird disconnect.
No, but you're on a particular platform which is necessarily going to have that narrative as a narrative that the majority of them adhere to from the beginning. So
I don't know if I've been downvoted to oblivion again on Reddit or Austin, because every time I open my mouth, I get downvoted. So last time I tried, all right, I'm going to say this: I believe in everyone's right to protest, but at least what I saw, I didn't see a problem. I'm thinking about going. I think it's only virtual because of the whole COVID thing, but there's supposed to be a town council meeting on Thursday to address this because they have to give 72 hours notice. So Thursday was the earliest they can do it. So I was thinking about attending and maybe signing up to speak, and I didn't see anything wrong, and seeing how well that goes over with my fellow Austinites community. I want to stand up and use my freedom of speech to support the government. Let's see if that goes over well. That'd be good.
Well, I think at the end of the day, I think right now the protest, it's for something I think definitely 100% legitimate. It's really about violence against minority members of the community by the police, and this whole you see a guy get murdered on camera, and it takes a week for the person to get arrested. I think that's what the protests are about, and I think Antifa and I think these other parties have seen an opportunity. They've seen an opportunity to do all this stuff, and and it's hard when you do have a disorganized, the people in Minnesota aren't the same people in New York. These people in New York, they all got together one day and said, let's go out there and protest what happened in Minnesota. So there's really no crosstalk between these groups. And I think what happens is that when you're protesting out there with these large amounts of people, thousands of people across the country, there are going to be some idiots who thinking about, hey, let me just get what's mine. I think it's funny because when we did the protest training, when you're in law enforcement, there's particular riot training that you have to do, and there are signals and stuff that happen. So in the riot training, they always used to tell us that there are 3 types of protesters. There are some people who are there for the mission, right? We're protesting the mission. Then there's some people out there who are looking to get theirs. They don't care about the mission. They've been walking about a target. They see people broke into the target, and they're just going to get a TV. They're not out there to do any crime, but it is an opportunist, for instance. And then you have the people who are out there for different ends. We want to break into places. We want to do this. And when you have those 3 different groups, you're trying to protect the one who actually have the real grievance and trying to stop the other 2. And that's where I think that's the problem with law enforcement, because how can you tell? It's not like people have any type of uniforms on. You can tell these are the bad people, these are the good people. They're kind of all mixed together. And when you have that type of environment, it's a hell of a thing to the police, because everyone at that point is a suspect. You know what I mean? And and as someone who was in law enforcement, it is just very, very tough when you're in the midst of the muck. It's tough to say, this is a good guy and this is a bad guy. It just doesn't work that way.
Yeah. So I'm very sympathetic to that reality, and I try to put myself in that position too. At least on my channel, I cover a lot of police misconduct cases because I cover a lot of 1983 cases. So if you want to sue the police, your cause of action is 42 USC 1983. It comes up quite a lot. And so on my channel, I cover quite a lot of 1983 cases because people want to sue the police. And police get qualified immunity, which incidentally, for the record, I think needs to be reformed massively, if not eliminated, because I think it's overbroad. But that's another discussion for another day. But incidentally, my point was just that I'm aware of the police and what they can and cannot do, but I'm also aware that they can be very professional. And my observations were more of the professional rather than the 1983 police suck variety. At least is what I saw personally.
Well, listen, let me do this. My camera just all of a sudden died on me. So
yes, we noticed they don't like you anymore.
Well, I think it's the bandwidth or the slow internet.
Maybe because I know the other night it was wild. They had the curfew last night, and we were trying to see how many people was going to. But there was like massive people outside just because they say curfew, and Americans say F the curfew. We're going to go out here and spend all night in the streets and play music. So last night, and I think I sent it to you, Viva, about the curfew. Let me read this last super chat so I can let you guys get out of here. But it's in New York right now. It's insane. It's unbelievably insane. 109 super chat from Civil Rights MVMNT movement, riots and MLK et al. Where is your RMLK? Respect for Martin Luther King. Nonviolent protests. I think you can't paint everybody with a broad brush. I think there are people out there who are looking to do bad things, but I think there are some people out there who are not. Last one from Spicy. I can't find it, but I see it. It says, would love the stream later. Will it be saved? Yes. Just come back and click on this link. Click on the link. Listen, guys, we've gone through all the topics. My camera's now not working. I got kids out here beating the door saying, Daddy, we want food or we're going to call the cops on you. So, yeah. And they've already eaten. So I got the same problem upstairs. But listen, I want to thank my two guests.
I got.
Go ahead.
No, I was going to say I got the same problem, and I know one kid needs a nap right now because I hear some bad behavior upstairs.
Listen, for all my new members, if you became a member today and I didn't see it, I'm sorry because it was StreamYards. But yes, please, if you have become a member, I will be thanking you. If I missed your super chat, I will be thanking you. Thanks to all my moderators. Thanks to my guests. Thank you to you, Angry Roach. Awesome stream, guys. Hope you do this again. We do. We were on Uncivil Law's channel last time. We were on Viva's channel one time. We're on my channel. So yeah, so we love doing these things, and these are all such interesting things. And remember, my last thing for all you guys: if your lawyer has just been arrested for throwing Molotov cocktails at police, it's time to find a new lawyer. With that, my name is Nate Brody. That's Uncivil Law. That's Viva Frei. We are out of here. Take care, everyone, and peace.
Peace.